So an employee has been dismissed or has left the company. What you need to do is...
My name is 𝐻𝐸𝐴, employment lawyer and the principal of 𝐻𝐸𝐃 Chambers.
The industrial court process. So an employee has been dismissed or has left the company. What you need to do is lodge a P1 form first, meaning a complaint form of representation under section 20 to the nearest JPP. JPP will then set a conciliation meeting. So by law, you memang have to go for this conciliation, which is an officer from JPP try to help parties to see whether can settle the case or not. At the time, there will be negotiation, sometimes 1 round, sometimes 2 rounds, sometimes many rounds. Now, only if the officer thinks conciliation failed, negotiation unable to achieve a settlement, then only they will refer the case to the actual industrial court to be heard as a court case. Now, during conciliation process, lawyers cannot be there, but generally my clients come at the time for me to advise them on what is like a suitable settlement amount, what is the strength of their case, how they should approach the conciliation. I will advise them behind the scenes so that at least when they go and negotiate, they know what is fair and what is not fair. Sometimes the problem is you go and settle, pay 6 months, only realize actually you have a very strong case. Why do you go and settle it? So if you consult lawyers at the time, at least you know your rights and roughly what is a reasonable amount for settlement. And we normally advise how you should approach the settlement as well. What would be a good term? For example, if you cannot get settlement sum that is low, at least you get payment by installment, something like that. So help you manage your company better, manage the situation better. Of course, if you cannot achieve settlement, no choice, go to industrial court. First thing, court will ask the claimant to file the statement of claim, statement of case. Company to then file the statement in reply, which is company defense. Then claimant can file another time rejoinder to reply to defense. Then after that, you will file a bundle of documents and then witness statements. And then only you go for trial. The witnesses come to court and give evidence and lawyers will ask questions. And finally, will be a decision. After decision, if somebody don't pay, you go for enforcement proceedings. Sometimes you dissatisfy the decision, you go for appeals. So that is the rough industrial court process. Now, the thing about industrial court is it's very flexible. It's slightly more casual than a normal court. So sometimes the bundle of documents can file late, witness statement can file late, suddenly case postponed. It's very flexible. It depends on experience. So if you do more industrial court cases, then you know, okay, this is what is happening. Because it's not as strict as a normal civil court. So somebody with more experience will be better in managing this kind of situation because of how flexible, casual, informal the industrial court is. So if an employee managed to prove that you unfair dismissal, he can ask for reinstatement to be put back to his original job. He can also ask for backdated wages. Backdated wages meaning the salary that he lost because of your unfair dismissal until the day that he got back his job or until the day the court award the decision. So he lost all these wages, so you need to backdate these wages. If it's a probationer, maximum 12 months. If you're a full-time employee, 24 months. Now, a lot of times the claimant do not want to come back because the relationship has already soured. Then the court will give compensation in lieu of reinstatement. That is generally 1 month for issue of service. Now, in a very rare cases, courts may also award aggravated exemplary damages. For example, when the employer was really bad, really cruel, really bad faith, then courts may say, I want to give an extra punishment. Then they will award aggravated or exemplary damages. You can look at industrial court practice note number 3, which they say how you calculate it. And also sometimes after the awards has been calculated, there will be some discount, reduced a bit because of what? Because the employee got a new job after they left the old company. Or the employee is also a bit problematic, is a contributory misconduct. They also did something wrong. So the court may say, okay, this is the total award, but I cut 20% because he got a new job, because he also did something wrong. So it cut down. So this is generally how they calculate.